Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 246 of the NCDWI Guide podcast. On today's episode, we are talking about 5 characteristics of a trial lawyer. I have seen on a lot of lawyers' websites recently, either in the firm's name or as kind of a marketing tagline, basically an indication that the firm is a trial firm or that a individual lawyer is a trial lawyer. And in effect, anybody that is licensed to practice in the state of North Carolina could designate themselves as a trial lawyer. Even a lawyer that primarily does real estate transactions or wills or business formation, somebody that almost never steps foot into a courthouse and certainly not into a courtroom, could designate themselves as a trial lawyer because they have the ability by their bar number to take a case to trial, to try a case, represent somebody in the process of trial. So, I think when we're looking at these 5 characteristics of what does it mean to be a trial lawyer, and these are not exclusive, they're not in any particular rank. There are other characteristics that I think could be brought into what makes someone a trial lawyer, and certainly some people may not have the ones that I have on my list in their mental thought process of what does it mean to be a trial lawyer. But what do we mean when we're talking about trial? Well, we could just mean the process, obviously, of going through a actual procedure, court procedure of trial, whether that's by judge, whether that's in front of a jury, whether that is a civil or criminal matter, getting to a verdict, whether that's for a financial outcome, whether that's for, in a criminal case, obviously guilty or not guilty. So we could be talking about the process. But trial can also mean test. Another definition for trial is to test something, to test a process, to test a product, to put something to the test. And I think that both of these definitions, the actual procedure and the process of testing something, really speak to these characteristics of what does it mean to be a trial lawyer. And when somebody says, I'm a trial lawyer, what are they talking about when they mean that? Well, the first characteristic I would like to delve into is basically that the lawyer that says, I'm a trial lawyer, has what I would call a trial first mindset. A trial first mindset, which basically means in a criminal matter, in a DWI case, the case is going to trial unless the client decides otherwise. The mindset is this case is going to a verdict in a courtroom. We are going to be entering a not guilty plea. The state is going to have to try and prove each and every element of the crime charged, and ultimately a judge is going to have to render a verdict, or a jury is going to have to render a verdict. We're only going to enter a guilty plea if that's what the client wants to do. And obviously it's always the client's decision whether to push the case to trial or to enter a plea. But I think the first characteristic of a trial lawyer is this mentality of the case is going to trial. In your brain, from the get-go, trial is the default route. And one of the best ways I've ever seen this kind of expressed was through a civil litigation lawyer, Perry Fisher, in Asheville. And every time that he would talk to a client about their case, he does a lot of personal injury, does a lot of civil litigation, but every time that he would talk to a client about their case, he would talk about it from the consultation through the discovery process at depositions and preparing for that. Everything would be discussed in terms of here's what's going to happen when the case goes to trial. Not if, when the case goes to trial. So here's the question that I'm going to ask the defendant in trial. Here's what the insurance company is going to be looking for in trial when this case goes to trial. And again, it wasn't presented in this kind of like, if it gets to that point, depending on how everything shakes out, ultimately, if the case had to be tried, this is clearly the default position is here's how I am going to try this case in front of a jury. Here's the questions that I'm going to ask. Here's what we are building towards. Here's the evidence layout. And a client can feel that. A client can get the sense that this guy in his brain is going to trial. Again, in a DWI case, I think a lot of lawyers have very much a default plea mentality, and it can be expressed in a bunch of different ways. But here's one way that I've often seen it done is that in North Carolina, DWIs are really hard to attack, very difficult. There's a very high conviction rate on DWI cases. And so here is likely the sentencing outcome that we're looking at, whether you pled guilty or took the case to trial, even if they talk about case going to trial. But again, high conviction rate, difficult to attack, low percentage chance of the case being dismissed or judge or jury returning a verdict of not guilty. Those are the ways that it's kind of a default plea position. So I think when you talk to a trial lawyer, they are going to talk about your case in the consultation in terms of here is our process for looking into the holes that exist on the state's case. Here are the pieces of information that we need in order to determine what weaknesses there may be in the state proceeding to trial, or weaknesses that they would have with their case at trial. All of the discussion is framed in terms of the case going to trial. And again, from the client's perspective, in that initial consultation and then throughout the case, a client can hear in the way that you're presenting evidence to them, the way that you're talking about the case to them, whether or not you think there is a realistic chance of pushing the case to trial, whether or not you push cases to trial, whether you think this case is going to be handled only and exclusively in a plea to the crimes charged. They can get that out of the conversation with you without you having to say that specifically. If you're talking about the case in terms of trial, then you're showcasing that you are a trial lawyer. So this is something that is throughout the representation, during the consultation, in the follow-up, in the calls about the strategy of the case moving forward, in the calls about the discovery that is being observed. Even when you watch a video and the evidence is shitty for your client, it's, it doesn't, your client looks terrible on video, the reports, indicate impairment. The way that, again, a trial lawyer is presenting this is, when this case goes to trial, the state could show this video. And maybe you have knowledge in your particular jurisdiction about how closely a DA looks over video. And you can say the video is very bad, but when this case goes to trial, there is a good percentage in these type of cases that the DA doesn't show video or may decide not to showcase this. So it may not get presented. If it does, it will be bad for us at trial. The officer's report shows a lot of clues of impairment, but it's a one-sided report. At trial, I will get to ask these questions about the report. At trial, the officer it may be shown that the officer doesn't have a background in standardized field sobriety testing, training in standardized field sobriety testing, didn't do the tests appropriately. And so the clues that are indicated may not be given much weight by the judge or by the jury. So again, even where there is bad evidence, you're talking through how the case would look if it went to trial. It's being discussed in terms of the case going to trial. So characteristic number one of a trial lawyer is a trial first, default trial mindset, a trial first mindset. And everything around the case is discussed in the framework of that default trial mindset. Number two, from the outset, the case is prepped for trial. Characteristic number two, prep for trial begins on day one. Now, we've got a amazing criminal defense lawyer, Tony Shear, coming on the podcast here in a couple of weeks, and he is going to talk about kind of the critical mass action that he takes on a criminal case in the first 7 days following being retained. This basically violence of action, as I will reference, of moving the case in attack mode from day one. That's because he is a trial lawyer. When you get involved in a case and you have plans for pushing the case to trial, if you're a DWI lawyer, how quickly are you going out to the scene of the accident or the scene of the investigation, the scene of the checkpoint? How quickly are you going out to take a look at that scene? Because even if you're planning on doing a site review before trial, it may look wildly different in the wintertime than it does in the spring, even if you go out the same hour a day. Sun sets later, obviously, in the summer than it does in the spring. It might be completely pitch black at 5 o'clock at night in December. It may be, brilliantly sunny in the summertime. You may be able to see certain things through the trees at certain times of year. There's all kinds of logistics. Maybe there's leaves everywhere, making it difficult to kind of find a good place for field sobriety testing, if that's covered over rocks or something along those lines. I mean, you just don't know what you're going to find until you go take a look. So how quickly are you going to do an on-scene investigation? How quickly are you requesting discovery on a case? How quickly are you requesting any surveillance video? Because that may be deleted or gone. How quickly are you requesting video from the intox room? How quickly are you subpoenaing certain documents, videos from nearby businesses? All of this violence of action at the beginning of a case is critical, not only to preserve the evidence, but to start preparing the case for trial, to really get into a good default position. Obviously, the earlier in a case that you can be ready for trial, the better, right? You have different judges sitting at every district court setting, right? You have different personnel and people. And so doesn't mean that you want to try the case on the first court setting where it's actually put into a trial courtroom, but you want to be ready to try the case at the earliest possible opportunity. There may be great advantage in continuing the case for a long period of time, and a trial first lawyer may very well decide, I am going to push this case as long as possible because that gives us the best chance of a dismissal, the best chance of getting a good outcome in the case, and that's totally fine. But a trial lawyer is trying to get ready to push the case to trial as early as possible. So they are never caught in a bad situation. They are ready for the opportune time to ask the case to be tried. They have everything ready to go as early on as possible. So that violence of action after getting retained on a case, doing discovery, investigating, that is the trial first mindset. And even doing some of these things prior to the consultation or during the consultation. I have looked at Google Maps, looking at the accident site with a client in the initial consultation. Because again, it's showing here's kind of some of the issues that exist based on what we can look at together. The mindset is, how is this case going to be decided by a judge or a jury when it gets to a trial? So, characteristic number 2 is that a trial lawyer begins prepping the case for trial immediately on day 1. Characteristic number 3 is of a trial lawyer is a desire to win. A desire to win. I think part of the reason that trial work is so much fun, especially in the criminal context, is there is a declared winner and loser. There's a declared winner and loser. Now, unfortunately, in a criminal case, your client's never being declared innocent, right? Not guilty. But whether the verdict is guilty or not guilty, there is a pretty clear winner or loser in most criminal cases. And in a DWI case, a trial lawyer is somebody that desires a good outcome for their client. And it's not just, I want this, which I think is part of it, a real burning of the heart, a real passion for getting a not guilty verdict for your client and wanting that outcome, desiring that outcome, but putting in the work to make that happen. Going to CLEs to get better prepared for attacking cases. We have our upcoming CLE in Raleigh on March the 7th at Campbell Law in one of their beautiful courtrooms on attacking speed in a DWI case. Really contesting a stop based on speeding and utilizing the officer's training on speed enforcement, speed detection, time distance measurement, radar use, really attacking the officer's training when it comes to speed measuring devices, and time distance measurement. How do you get an expert witness involved in that kind of process? How do you see this play out in real time? That's part of the reason that we're doing this in a courtroom, is because we're not just talking about taking a case to trial. We want to show, here's how you take a case to trial. This is what the cross-examination of the officer looks like. We have 2 mock cross-examinations. Here is how you would tender an expert witness for your case on speed measuring devices. And Doug Scott is going to walk us through what that looks like. Are you putting in the time to improve your craft? Are you putting in the work on your individual case, watching the video? There have been so many times that in kind of weird offhanded moments, you have a video that's an hour and a half long. There's not, anything really one way or the other in the field sobriety test. They're going down to the jail. The officer has gone through the breath rights. Officer steps away for a brief moment and observation period is in question. Or at the jail, an hour plus into the video, the officer steps over to the magistrate judge and says, yeah, I didn't see much on the SFSTs, but he just blew a .08, right? So now, well, let's use that in the PC hearing, right? You indicated that you didn't think that there was a lot of clues on the SFSTs. Is that correct? There's all kinds of nuggets, but we have to put in the work. And a trial lawyer wants to win bad enough that they will go in prepared, that they will do the digging and research into the case law and statutory framework surrounding DWIs so as to be able to put forth the best argument for their client. They will sink their teeth into the discovery because they want to have a good outcome in the courtroom. They will study and learn and bounce their case off of other trial lawyers, not feeling down about that, not feeling humiliated about that, but looking very humbly for advice about how they can improve their case. Trial first. Trial lawyers have the characteristic that they desire to win and thus put in the work to make that a reality. So number 3, the desire to win. Number 4 characteristic of a trial lawyer is the lack of fear. The lack of fear to try a bad case. Trial lawyers are not afraid to try a case with bad facts, bad law, or both, right? In law school, and I've talked about this in the past, and obviously everybody probably heard this at one point or another in law school, but in law school, they tell you if you got bad facts, argue the law. If you got bad law, argue the facts. If both the facts and the law are bad, argue like hell, right? Argue like hell. And I think there's something built into us that when we have a bad case, and by bad case, I just mean, a case where there's not a great argument based on the evidence and based on the law to expect a not guilty outcome. I think most of us want to have, when we push a case to trial, some sort of an angle about why this evidence should not come in, or why substantively the state cannot prove one of these essential elements of the charge, and therefore an argument that my client is not guilty. We want to have an angle. We want to have an argument. But what about the cases where there is just nothing that really seems to be on your client's side? What about a situation where there just isn't much to argue? Do you feel uncomfortable pushing that case to trial? I will tell you, in talking with other lawyers at the firm and in looking at my own mentality and talking with colleagues, most people do not want to push a case to trial where they don't have an argument. And here is the primary reason why. They don't want to look silly. Secondary reason, or another reason, might be they don't want to have their client get a worse outcome from the judge by pushing a nonsensical case to trial and upsetting the judge, wasting judicial resources, right? This is kind of like the mindset. But when you have a client that wants to push a case to trial, I feel like there's so many times where there's this immense amount of energy and effort that is spent trying to convince a client to plead guilty. And I can remember a very specific case that I had in Buncombe County many years back. I thought we had a great stop issue. Officer had lost sight of my client's car, going down a very busy local road, Patton Avenue, relocated it. Minutes later, it was basically a very generic car, common color. I think it was black or white, but common color sedan, no license plate identified. Basically, didn't seem like the officer had any real way of connecting the bad driving that he had observed minutes earlier with the car that was now parked on the side of the road miles away from that, and also minutes later. But the judge found that it was reasonable suspicion, and my client ultimately blew a .16. So after the pretrial suppression motion, the case was continued for trial decision. And I told my client, look, we got nothing. I think it was about 3 months, 2 or 3 months later, that it got rescheduled for trial. I said multiple times in the interim, we've got nothing. The .16 is coming in. The judge has found that you stopped. That was your car that was stopped. There was nothing to argue. I mean, I was like, I was looking sideways at the case. There's just nothing. It was like, this was not a good case to take to trial in my mind. And my client was a college student. He apparently wanted to go to the casino courtroom, right? Wanted to roll the dice. And he was just like, there's no difference in terms of the outcome. Let's just push it to trial and see what happens. And it's like, it's a waste of time. You end up, wasting the court's time. I don't know if that's going to, what the additional evidence is about, kind of your attitude with the officer. It could end up badly for us in sentencing. I'd spent all this emotional capital, and I was feeling this like anxiety of, what am I going to say? And, it was my fear of, I don't want to look like I am pursuing a case that is a bad factual case. Ultimately, the judge, after hearing all the evidence, including the breath test, district court judge, found my client not guilty. And the district attorney on the case looked over at me sideways like, what the heck happened? I was looking back at him completely stunned. Afterwards in the back room, he was like, what was that all about? And it's, literally, I just didn't have an explanation. My client was like, that's exactly what I expected to have happen. And yeah, totally was able to be like, see, I told you so. But again, that was a huge learning lesson for me of, just because you don't have a good case to take to trial doesn't mean you shouldn't take it to trial. You don't know what is going to happen on a case unless you push it to trial. You will absolutely miss 100% of the shots that you don't take, as is the Wayne Gretzky quote. You got to push bad cases to trial. If you're only trying a .07 case, if you're only trying a prescription medication case, and that's not an easy case to try. But if you're only trying cases where it's a real clear, bright line, hey, there's either an issue or the state should not be pushing this to trial, then you're not a trial lawyer. On the flip side, if you're not pushing a .07 case to trial, you're absolutely not a trial lawyer. And I don't care what the other circumstances are related to the case. Again, there might be sentencing reasons for doing something different, but yeah, there are certain cases where you just have to push it to trial. So if you're only pushing what appear to be the winners to trial, then that is not the characteristic of a trial lawyer. A trial lawyer is unafraid to take a bad case, a quote unquote unwinnable case, to trial. Because that may be your client's desire. And pushing it to trial is absolutely what you should do in that circumstance. So, number 4, trial lawyer is unafraid to take a bad case to trial. And finally, number 5, and this is somewhat connected, but slightly different. A characteristic of a trial lawyer is that a trial lawyer is unafraid to pursue a nuanced issue or innovative argument. Trial lawyer is unafraid to pursue a nuanced issue or innovative argument. Again, there's this somewhat goes back to the desire to win. It goes back to this lack of fear of looking silly. But if you are routinely taking cases to trial, you should be unafraid to test new issues, to push the complex areas of law and really grapple with it and wrap your brain around it and try to figure out ways of simplifying it and presenting it to the judge. I think State versus Knoll is one of these issues. The case law and legal framework around Knoll is so complicated that a lot of lawyers don't feel comfortable pushing that issue because it requires a lot of distilling of nuanced legal issues. A lot of attorneys don't want to push an issue that's never been tried in that county before. Well, this doesn't work in our county. Yeah, it might not, but it might. And it might take arguing it 10 times before it's kind of like, you know what, I think that there's something to this, or the judge sees it in a different light, or multiple judges are getting the same argument and then discussing it in the back and saying, this lawyer has presented this issue. What do you think about this, right? Sometimes the real-time decision-making that happens in the courtroom gets reflected on later in the chambers, later months down the road in the same courtroom, and the outcome might be different depending on maybe slightly different facts, depending on the judge having had time to think about the argument that was made, to reflect on the case law that was presented, to reread that, to ask other judges at a judicial conference about this particular nuanced issue that you have raised. So this is something that is, to me, very much a characteristic of a trial lawyer, is this mentality of pushing untried issues, being the first to present a specific legal challenge. So there you have it. There are 5 characteristics of a trial lawyer. Again, can add a lot to that list. It's a non-exclusive list, but if you are telling the world, telling your clients, telling yourself that you are a trial first lawyer, those are 5 characteristics that I would expect you have walking into the office to talk to your client walking into the courtroom to push your case. Get out and try some cases in 2025. Looking forward to speaking with you again next time.